So all of you, we have shared a live stream link on uh, various platforms. So you people can share them to your fellow stream link on we- so you all can share these links to your friends, family, or faculty, and we are okay with you people sharing that link. Okay. Is my voice clear to all of you?
Yes, sir.
Okay, ठीक है.
Yes, sir.
Okay, so we'll do one thing. We'll close all breakout rooms and the judges can come here. So all are here, right? We can start the rounds, correct?
Yes, yes.
Okay, I'll close the breakout rooms. Hello, ma'am. Good evening. We
Yes,
welcome you to this edition of the virtual moot court competition. We are happy to have you this year as well, ma'am.
shall we start?
Sir is just joining and we just close the rooms. He'll be shortly joining. 60 seconds and he'll join. S yes. Sir, can we start, sir? Sir's mic is good evening, sir.
Good
We
evening.
welcome you again, sir,
Thank you.
for this edition of the virtual moot court.
Yeah.
For your convenience.
Yeah.
So you can see everyone. Yes.
Yes. I
So
could not hear me. Yeah. Fine.
yes, sir, I'll Rahul, do you have the rights to spotlight?
No, sir. Or the host has.
Okay, we'll do one thing. We'll just spotlight each speaker and the whoever is speaking will do that. Uh, Courtmaster, are you live streamed? Are you spotlighted? Who's the next Courtmaster? Vaishnavi, is it?
Yes, sir.
Yes, sir.
Okay. Who's going to be speaker one from the appellant? Raise your hand, please.
Mm.
Speaker one from the appellant, please raise your hand and unmute yourself.
Master Arpan, you are not
Yes.
totally visible. Arpan, Master Arpan, adjust your camera. Similarly, speaker one, TGA 18.
Speaker one, TG18.
Yes, sir. I think that's the screen.
Screen is not okay. Fine. It's okay.
Shubhra, kindly use
Yeah.
a gallery view over there.
It's okay.
Yes, sir. Done.
Yes, done.
Yes, I'm starting the recording, sir. So yes. Courtmasters, you can start the round.
Yes, sir. Good afternoon, everyone. On behalf of organizing committee, I warmly welcome you all to the 6th TGA Virtual Moot Court Competition 2025 conducted by Thomas George and Associates. I am Vaishnavi Upadhyay and I will be acting as the court master for today. Before we begin, I request all the participants to keep their cameras on throughout the proceedings and kindly ensure that any technical issue are communicated immediately through the chat box. For today's round, we are honored to have Honorable Sri Justice Gadi Praveen Kumar and Honorable Mrs. Justice Suryapalli Nanda Ma'am as our esteemed judges to adjudicate this round. And we extend a warm welcome to the judges for taking out their time from their busy schedule. Now, with the permission of bench, I will proceed with the introduction of our honorable judges. Honorable Mrs. Justice Suryapalli Nanda Madam, She has enrolled as an advocate on the rolls of Bar Council of Andhra Pradesh on 4th August 1993, joined the office of Honorable Justice G. Chandraya Garu, later worked as a junior counsel assisting V. Rajagopal Reddy Garu, senior advocate, actively practiced for more than 28 years at the High Court of Judicature at Hyderabad, dealt with all the type of constitutional, criminal, labor, revenue, and service matter, specialized in the area of writs. Pro bono work for the Legal Service Authority, worked as a panel advocate for AP State Legal Authority in the High Court of AP, and continued as such till elevation as the judge in High Court of Telangana. Held the assignment of master trainer and trained in the legal panel lawyer of all district of Telangana on advancing of lawyering skill in the year 2015 along with the two other master trainers. In her past year, ma'am has been awarded with various positions. She was officially appointed as Standing Counsel for the Bar Council of India in the year 2006 and continued as such till elevation on the Judge High Court of Telangana. Worked as Assistant Government Pleader for Panchayati Raj, worked as Assistant Government Pleader for Land Acquisition, worked as reporter India Law Report, Law Journal of High Court AP, appointed as Central Government Counsel, dealt with all the cases pertaining to external panel advocate Government Counsel to represent Union of India in cases relating to grant of Central Sanman pension, legal advisor to Nizam's Institute of Medical Science. She was appointed as panel advocate for Corporation Bank, panel advocate for Oriental Bank of Commerce, member inquiry committee to inquire into the complaints regarding the alleged indecent representative of women IAS officer. Standing Counsel for National Institute of Rural Development and Panchayati Raj, panel advocate for National Commission for Women, dealt with cases on behalf of Petroleum and Natural Gas Regulatory Body, New Delhi, as a special counsel. The member of Institutional Ethics Committee of Medical and Health Research Institute, Maternal Health Research Trust, legal expertise in NRI Women's Safety Cell, Women's Safety Wing, Telangana. Member of High Court Gender, Sensation and International Complaints Committee. She was appointed as a council representative Haji AP Bawa and Construction Private Limited, designated as a senior counsel and is the first woman to have been designated as a senior advocate after the establishment of the state of Telangana. She was nominated as a member of five-member interview cum interaction committee to conduct interview cum interaction for improvement of legal assistant for NIR DPR, impaneled as a senior advocate on behalf of High Court Telangana on important legal notice. Nominated as a member, Board of Study, Faculty of Law, Osmania University. There are more than 64 reported judgments reported in various law journals in the cases dealt as an advocate. She was elected as an executive committee member of AP High Court, advocate associating for 3 terms, elected as a secretary, AP High Court Advocate Association. She was nominated as returning officer to conduct the AP High Court Bar Association, life member, India Law Institute, New Delhi, and recipient of Elders Club Excellence Award, recipient of Acharya Chanak Sadbhavna Purushkar Award, recipient of National Unity Award, elevated and sworn in a permanent judge of High Court of State of Telangana, authored more than 640 reported judgment and acquired extensive experience in dispensing justice at the High Court of Telangana. Member of Commonwealth Magistrate and the Judge Association, London. Member of International Association of Women Judge, Washington, D.C., USA. Thank you, ma'am.
At the outset, I extend a warm welcome to our Honorable Justice Gadi Praveen Kumar sir and Honorable Justice Suryapalli Nanda ma'am for this final round. It is my privilege as the court master to introduce the lordship present in this virtual courtroom today. Honorable Justice Gadi Praveen Kumar sir enrolled as an advocate on 12th November 1998 with the Bar Council of the then Andhra Pradesh He initially joined the chamber of Sri Jitendra Rao and Sri A. Lakshmi Narayana Reddy advocates at Warangal trial courts, and later he joined the office of senior counsel Sri A. K. Jayaprakash Rao, advocate at High Court, and gained exposure to various branches of law. Sir actively practiced in the areas of constitutional law, civil law, criminal law, labor law, service law, and family matters. Served as standing counsel for the Enforcement Directorate, a department of the Government of India, Mint, Armed Forces Tribunal, Security Printing Press, National Institute of Nutrition, and other central government departments covering various branches of law. Practiced for more than 27 years in various branches of law, Honorable Justice G. Pravin Kumar Sir had been appointed as Central Government Standing Counsel in 2015 and served the department in this capacity, also holding the position of Senior Standing Counsel for the central government. Later, in October 2022, Sir was appointed as Deputy Solicitor General of India for the High Court of the State of Telangana and served various ministries of the central government until he was elevated as an additional judge of the High Court of the state of Telangana. Sir has been appointed as an additional judge of the High Court for the state of Telangana and assumed charge on July 31st, 2025. Sir firmly believes that hard and honest work never goes unrewarded. With the permission of the Honorable Bench, shall I now briefly outline the rules and structure of today's proceedings?
Yes, go ahead.
Each counsel will be allotted 15 minutes, subject to an extension at the discretion of the Honorable Bench. We humbly request the bench to kindly keep the time frame in the consideration due to a fixed schedule. During the arguments, I will be informing both the sides when 3 minutes remain, when 1 minute remain, and when the time is up. In the event of any connectivity issues causing an interruption, a maximum relaxation of 5 minutes may be granted, which is again at the discretion of the bench. The structure for the rounds will be as follows. Counsel 1 and Counsel 2 of the appellant will present their case and arguments first. This will be followed by Counsel 1 and Counsel 2 of the respondents. A stable internet connection is mandatory for all participants, and cameras must remain on at all times during the rounds. Judgments or documents may be screen shared only with the prior permission of the bench. Rebuttals and sub-rebuttals, if any, will be permitted solely at the discretion of the judges. Best of luck to all the teams. With the permission of the Honorable Bench, may we now begin the session?
Yes, please. All the best to all.
Yes, proceed.
May it please the Honorable Bench, we are the counsels humbly appearing on behalf of the appellant ABC Bank before this Honorable Court. The counsel seeks permission to address the court collectively as the Honorable Bench.
Yes, proceed.
Much obliged. The counsel also seeks permission to screen share the compendium.
Yes.
Much obliged. With the Honorable Bench's permission, I wish to briefly outline the issues that we will be addressing. I will be advancing with the submissions on issues 1 and 2, and my co-counsel shall be subsequently addressing the remaining issues, that is issue 3 and issue 4. The counsel respectfully submits that 15 minutes have been reserved for each counsel submission, and we shall endeavor to remain within the allotted time. With the kind permission of the Honorable Bench, counsel shall now proceed with establishing the facts of the case.
Yes, proceed.
Much obliged, Your Ladyship. The present appeal arises from a prolonged and unfortunate history of default by the corporate debtor. ABC Bank, our client, sanctioned financial assistance of rupees 500 crores to the corporate debtor, which initially serviced the loan but soon had defaulted, resulting in an account as being classified as a non-performing asset on 1st April 2014. Through continuous change of restructuring and OTS proposals ranging from the years 2014 to 2022, clearly affirming that the subsisting debt exists and there is also default. Yet, when my client had sanctioned in favor of the OTS letter dated 1st January 2020, XYZ Limited had failed to make the payment as agreed on by the OTS letter dated 1st February 2020, whereby they were obliged to make the repayment on the entire liability amount as they had agreed to on and before 31st March 2020. Now, in the year 2020, during the pandemic had hit India, when the Section 10A had been introduced, it temporarily suspended IBC filings for defaults that were arising solely during that very notified period. And thereafter, from the date that is 25th March 2020 to a maximum period of 1 year, my client's first Section 7 application that was filed in the year 2022, quoting the OTS cancellation date, that was dismissed only on the basis of Section 10A. That was merely a temporary statutory bar, not on the merits or the lack of the subsisting date. In fact, no adjudication ever occurred on the very existence of the debt or default. In 2024, my client filed a fresh Section 7 application based on the original NPA date, supported by continuous acknowledgements that were well within the limitation. Yet, the NCLT and NCLAT had erroneously held that the bank was barred by means of res judicata and could not change the date of default. Honorable Bench, our present application challenges these findings as both these orders stand defeated and the object of the IPC as to be justly uplifted. With the Honorable Bench's permission, I shall now move on to the submissions.
Before you proceed further, why was an appeal not filed before the Honorable Supreme Court in the first round of litigation?
Honorable Bench, on the first matter, we had not filed it before the Honorable Supreme Court because we wanted to consider the date of NPA actual to our for the purpose of determining where the debt had arisen from. In the second one, it was the OTS proposals that we were considering. But in this second application, it is the actual NPA default date that we are construing.
Can the date of default be the same as date of classification as NPA?
No, Your Honor, it cannot be. The date of default is when from the default has actually come to existence, and the other one is from the date that it is being filed or brought up before the court.
Res judicata is a universal principle applicable even in IBC proceedings. So how is the present second application maintainable under Section 7 IBC?
Yes, Your Ladyship, but the sheer fact that the case was barred by the means of a statutory norm that to temporary in nature in the light of the COVID virus, and not on any merit of the matter or for the absence of the debt or the default. So in this matter, res judicata should not apply because the matter has not even been put forth before the court, and we do have the natural justice of audio alterum partem that is to be heard.
Is there any case law in support of your case?
Yes, Your Ladyship, we will be discussing further that in our issues.
Yes, proceed further.
Much obliged, Your Ladyship. As it may please the Honorable Bench, I shall move on to the issue 1, which determines whether or not a second application under Section 7 of IBC is barred by law. Honorable Bench, we submit respectfully that in rejection of the first Section 7 application, it was not the merits of the debt or the default due to which it was barred, but it was sheerly under Section 10A of the IBC, a provision that was enacted during the pandemic to give relief. It is a well settled law in India that a dismissal on procedural grounds cannot actually operate as res judicata. A rejection under Section 7(5) for technical defects do not determine a debt or default on merits and cannot bar a subsequent application. To this, I would like to cite the case of Dena Bank versus Shivakumar Reddy. Also, Your Lordship, Honorable Bench, the first application did not adjudicate the underlying debt in any manner. It was a temporary technical embargo. Section 10A did not extinguish the creditor's substantive rights of getting back the defaulted loan amount. It merely created a pause, a temporary suspension, that too without affecting the legal foundation of our claim. Once the embargo ceased, the creditor's rights had been going on to the initial proceedings were revived. Also, only a judicial decision on the merits will preclude a subsequent suit or proceeding on the same cause. Honorable Bench, it is humbly submitted that by the virtue of Section 238 of IBC, the provision of IBC have an overriding effect over all other civil laws when it comes in contradiction to IBC. Consequently, the doctrines developed over general civil jurisprudence, such as that of res judicata, cannot defeat or dilute the substantive scheme of IBC, particularly when there has been no jurisdiction on the basis of the merits. Honorable Bench, this position has been equivocally also affirmed in the matter of Innovative Industries Limited versus ICICI Bank 2018, where the Supreme Court had held that the IBC is a complete court by itself and its provisions must prevail. Wherever there is any inconsistency with other laws, it has to be of utmost importance. More importantly, the court even noted that the adjudicating authority is only required to examine two things: the existence of a debt and the occurrence of the default, and no other extraneous or technical considerations can bar the admission of a petition. In our current case, the earlier dismissal was purely on the basis of a temporary statutory bar, and the matter did not even get adjudicated. That is the core issue of debt or default. Therefore, in this matter, res judicata cannot really operate. Also, this principle has been reinforced by the Supreme Court and NCLAT in multiple cases where it has been consistently held that technical dismissals should not frustrate the objective of the very court, that is, to uphold the preamble of IBC, which aims at ensuring that the genuine cases of debt and default that enter into the resolution process are taken place in a time bound and efficient manner, and to deny a second application under Section 7 on the ground of procedural bar would directly contradict such the spirit of the court. Honorable Bench, I would also respectfully submit that the court is event triggered and not sheerly claim triggered, such that each continuing default constitutes of a recurring cause of action. And this has also been held in the case of Dena Bank versus Shivakumar Reddy, 2021. Internationally, even the English House of Lords have emphasized that the final decision of a substantive matter precludes relitigation. Even repeated filings are permissible after a procedural dismissal, provided that the subsequent application satisfies the eligibility conditions, that is, the prevalence of a debt and default. The courts have also consistently clarified that pleadings cannot override the documentary evidences. The case of BK Educational Services versus Parag Gupta, the Supreme Court had held that limitation begins when the default occurs, and this is to be construed as the basis of documentary evidences. Your Honorable Bench, the Council respectfully submits that the present case, the default commenced back in the year 2014, and this position is supported by the creditor's books, bank records, and even the debtor's own correspondences. This earlier position was not dismissed due to the absence of default, but only for the temporary statutory bar considering the COVID pandemic situations, which inadvertently placed the claim into Section 10A, that is within the restrictive period. Honorable Bench, IBC nowhere prohibits the filing of a fresh petition with a different cause of action and different default date, especially when the underlying debt and default in question are subsisting and forms a recurring part of the cause of action. We understand that a temporary statutory bar is allowed to bar a legitimate recovery, but such that has to be within a restrictive time period, and if it is uh, let allowed to be gone for a long period of time, it would weaponize the procedure to defeat the substantive justice. Thereby, rejection of the Section 7 application cannot be treated as res judicata. Also, the appellants actually restrained. Uh, Actually, we are being restrained of our legitimate right to approach the honorable court after the cessation of Section 10A's temporary bar, as it is a mean of appeal or means of a second application, and denying such a right would imperil our substantial rights and defeat the very legislative purpose of the IBC. If your lordship permits, I shall move on to the second issue.
Proceed.
Much obliged, lordship. So the second issue being here, whether mentioning of the date of default is mandatory in an application under of IBC. Honorable bench, it is respectfully submitted that the determination of the date of default is a matter of fact and not otherwise. We are not denying it is a jurisdictional fact. Also, what governs the date of default is a factual record that constitutes of loan agreements, bank statements, recall notices, and all the admitted conduct of the debtor. Courts have consistently emphasized that a documentary evidence or the actual fact of the default form the pivotal point. I would like to cite the case of BK Educational Services versus Parag Gupta and Associates. In this case, the Supreme Court had held that the limitation clock for IBC applications begin the moment the default occurs and not on the filing of the application, nor on the enactment of the code. This reinforces the principle that date of default is a factual inquiry and it cannot be manipulated or shifted in any matter for procedural advantages. It is further submitted that the earlier dismissal of the application was not due to any absence of default, and even the respondents, they cannot deny the subsistence of a particular default and debt from their part, and it has already been discussed in the previous issue. A creditor cannot be prejudiced for a temporary statutory bar, especially when the underlying debt and default remains undisputed. Honorable bench, the section 10A that was enacted was a temporary relief only to prevent initiation of proceedings for that very period, that is restricted from 25th March to 6 months, and if not further mentioned, to a period of 1 year. And the explanation of section 10A clearly clarifies that such shall not be applicable in the cases where the default has been committed prior to that very period. And it does not erase the defaults that predate the very pandemic period, such that in our case, which began in 1st April 2020, 2014, when the company was declared as NPA, and in this case, the respondents cannot revoke 10A as a shield would unjustly convert a temporary pandemic measure into a permanent immunity for a chronic defaulter like them. Honorable bench, in this case, I also want to cite the case of K. Shashidhar versus Indian Overseas Bank
What
and
is the
others.
date of default? What is the
Your
date of
Lordship,
default?
in our second application, we are considering as 1st April 2014 when the company was declared as NPA.
So how do you justify that the date of default need not be referred?
Your Lordship, if you could, my pardon.
How do you justify that the date of default did not be mentioned?
Your Lordship, it is a jurisdictional fact and it has to be mentioned. Section 7 clearly mentions that the date of default has to be mentioned for the enquiry of a very proceeding to even begin with.
Yes. Next.
Much obliged, Your Lordship. If I could continue.
Yes, proceed.
Much obliged, Your Lordship. So, in the case of K. Shashidhar versus Indian Overseas Bank and others, it was held that if a revised date of default shows a default within the maintainable period, the court may even accept such a revised petition. This strengthens the principle that a creditor's right to sue under IBC is substantive and not defeated by any form of temporary statutory bars and not even by any form of temporary procedural discrepancies. Additionally, to the respondents, multiple repeated OTS proposals and correspondence constitute of a valid acknowledgement of the debt, even if they may even ask it to be conditional, but it still exists. And also, be it conditional or negotiated proposals, admitting a subsisting liability extend the limitation period thereby under Section 80 of the Limitations Act. The respondent's own communication clearly acknowledged the overdue amounts and the obligations to regularize their liabilities. Consequently, the limitation period is extended and the petition is very well within the time period and stands entirely maintainable. Honorable bench, the mention of the default date is clearly a mandatory and jurisdictional fact. Yet it cannot defeat the substantive rights that the creditor has. The factual default has been established beyond doubt, and the second petition clearly reflects the reality of the case, and the appellant is fully entitled to proceed. If the honorable bench permits, my co-counsel shall take over the issue 3.
Yes.
Speaker number 2 to come in. Speaker number 1, time is up.
Honorable bench, the council seeks permission to continue with issue 3.
Yes.
Much obliged, Honorable Bench. Issue 3 states whether or not the date of default changes based on facts and circumstances, or is it to be taken as the date of NPA in all bank matters. The council humbly submits that the date of default is not rigid or mechanical. Instead, it depends on the factual matrix of the case. Such a date can be the date of NPA, which is a later missed payment, or even be influenced by a subsequent acknowledgement of liability. Honorable Bench, the Honorable Supreme Court in a catena of judgments has held that it is the date of default and not the date of NPA that strictly triggers the cause of action. Thus, the date of default can change based on the facts and circumstances of a case, and it is not always necessary to use the date of NPA as the date of default in all bank matters. Further, the council pleads that the NCLAD erred in dismissing our application solely because the date of default was changed between the filings. We submit that the operative date of default under the Insolvency and Bankruptcy Code is a flexible question of fact and not a mechanical label frozen to the non-performing asset date. The law permits us to rely on any date that accurately reflects a clear instance of non-payment, especially when the date is created by subsequent conduct of the corporate debtor itself. Further, the corporate debtor's liability did not end when the account became NPA in 2014. Honorable Bench, the facts clearly shows a continuing shifting relationship. The debtor admitted liability repeatedly through the letters seeking restructuring from 2017 to 2022. Crucially, the bank sanctioned an OTS in February 2020, which created a fresh as well as a binding repayment obligation. When the debtor failed to honor this, the bank had to cancel the OTS on 1st May 2020. This cancellation represents the last definitive act of non-payment after a renewed commercial attempt. Therefore, the bank is legally entitled to plead either the NPA date of 1st April 2014, which is the documentary starting point, or the OTS cancellation date of 1st May 2020, which is the actionable failure of revived arrangement, where both dates point to the undeniable reality, Honorable Bench, that the debtor owes the money. Further, the council would contend that the corporate debtor's multiple written requests of OTS and the restructuring serve as the formal acknowledgement of liability under Section 18 of the Limitations Act. These acknowledgements made years from 2014 to 2022 legally restarted the limitations clock, ensuring that the debt remained to live. To deny the bank the right to rely on a later date, like as the second application, that 1st May 2020 OTS cancellation date, would effectively punish the bank for engaging in nothing but good faith in commercial negotiation and restructuring. The law must not incentivize debtors to use negotiations to build a limitation defense. Honorable Bench, it must instead honor the fact that OTS letters kept the debt relationship operational as well as justified a later actionable default date. Honorable Bench, the council would like to refer to the case of BK Educational Services versus Parag Gupta, where it was established that the Limitations Act applies to IBC applications, making subsequent acknowledgements crucial for determining a legally enforceable default. The Supreme Court has also repeatedly held that the date of default is the question of fact and not a mechanical label. The trigger is the non-actual payment, and the date can be influenced by subsequent events like the acknowledgement. Honorable Bench, the council would like to throw light on the applications of the facts here. The bank's two pleaded dates reflect two lawful supportable default points. First is that the first filing, that is 1st May 2020, that was the first filing. The date represents the fresh actionable default that arose from the debtor's failure to honor the sanctioned OTS, which was the latest definitive breach of promise. In the second filing, the date of 1st April 2014, this date represents the legally sound date of NPA, which the bank used in the second filing to conclusively prove that the debt was outside the Section 10A. The bank then used the numerous OTS letters from 2017 to 2022 to demonstrate that the debt was within the 3-year limitation. Honorable Bench, the change of the date in the second application was not arbitrary. It was a necessary legal strategy just to overcome the technical bar of Section 10A and ensure that the debt's recoverability under Limitations Act. The bank's choice was guided by the judicial history of the case, not by any fancy. Further, the council would like to contend that the corporate debtor was not misled. All the documents, including the certificates, the OTS sanction, as well as the OTS cancellation acknowledgement letters, were part of the case record in both the filings. The core fact is that the debtor owes the money and has not paid for 10 years. That remains completely unchanged. Honorable Bench, the council would plead by changing the date to the original NPA and relying on the legal effect of acknowledgement letter, the bank was merely navigating the complex interplay between IBC, the COVID bar, as well as the Limitation Act. And this action should not upheld as commercially prudent and legally sound.
What is the difference between NPA and the date of default?
Honorable Bench, default is the cause, which is defined in Section 3, subsection 12 of IBC. It defines that default is a non-payment when the debt is due and payable, and NPA is nothing but the consequence of default.
Then how is the loan account classified as NPA by the banks?
Honorable Bench, both the dates, the NPA date of 1st April 2014 and the OTS failure date of 1st April 2020, these are independently legitimate factual defaults, which are supported by documents already in record by both the filings. And the bank did not change the date of manufacturing jurisdiction. It changed the date only because the Section 10A created a statutory bar, and further, the underlying debt remained continuous and had a repeated acknowledgement, Honorable Bench.
Yes.
If the Honorable Bench is satisfied with the arguments, the council would like to proceed with issue number 4.
You have a remedy of filing an application.
Honorable Bench, there is, if the council is not wrong, there is no remedy of refiling. There's an amendment that the amendment through different statutes where amendment, if only there is an error or a clerical error present in the particular application, only then the IBC provides amendments for that application only. The council would like to answer this question in the further arguments in issue 4.
Okay.
Much obliged, Honorable Bench. Issue 4 states whether or not a case can be admitted if the default has occurred and the application is within the limitation, despite an error in the date of default. Honorable Bench, courts have consistently held that procedural variations, such as the change or clarification in the date of default, do not bar admission under Section 7. The object of IBC is resolution and not technical rejection. Courts and tribunals have or may permit amendment or revisions of pleadings at any stage prior to the final adjudication. There are also international jurisdictions that follow the doctrine of substantial compliance, where clerical or formal discrepancy do not defeat substantive rights. Honorable Bench, to answer the question, there was no clerical error, or the council here does not admit to the fact that it was a typo. The council states that the bank had made the necessary legal strategy to overcome the technical bar of Section 10A, and that the change was not a clerical error, but it was arbitrary. Further, the council would like to contend that providing clarified or updated default date in a revised petition, which is not an amendment, it's a revised petition, is a valid legal strategy, especially when the record clearly reflects multiple points of default and repeated acknowledgements by the corporate debtor. The appellant's filing was not a mistake, Honorable Bench. It was a deliberate refinement to correctly reflect the most appropriate date arising from the subsequent conduct of the debtor. Honorable Bench, the council would further proceed with the court's purpose, which states that it is revival and resolution and not mechanical dismissal. In the case of Mobilox Innovations Private Limited versus Kirusa Software Private Limited, the Supreme Court held that procedural lapses should not undermine substantive justice. Honorable Bench, hence, a strategic revision of default date when default itself is undisputed cannot defeat the insolvency process. Further, the council would contend that the courts have consistently prioritized the existence of an actual default and continuous acknowledgements of the liabilities over a rigid procedural formality. The council would like to refer to another case, that is Valal RCK versus Siva Industries and Holdings Limited 2022, where
Before you proceed with that case,
yes, Honorable
we would
Bench.
want to know what is the date of default mentioned in the first round of litigation, and what is the date of default mentioned in the second round of litigation.
Honorable Bench, the council would like to plead that the first application which was filed by the bank, the date of default was 1st May 2020. And during the second filing of the application, the date was changed to 1st April 2014.
Then how do you explain that the second application would be within limitation?
Honorable Bench, Section 18 requires only two elements. One is the written statement, and the other is the indication of substantive juror relationship between the debtor and the creditor. Here, stating the acknowledgement of the corporate debtor from 2017 to 2022, where the council over here states that the bank had filed in 2022. In 2022, only when the OTS was cancelled in 2020. And limitation states that we have time from till 3 years. So from 2020 to 2023, there was the limitation period, but the bank, through the acknowledgement in 2022, provided under Section 18, filed for an application from the date of 2020.
Yes. Any case law in support of your case?
Yes, Honorable Bench, the council would like to answer to this case law in the further arguments.
Yes, proceed.
Much obliged, Honorable Bench. The council contends that the courts have consistently prioritized the existence of the actual default and continuous acknowledgements of liability over rigid procedural formalities. Now, in the case of Valal RCK, the Supreme Court stressed that the substantive justice must prevail and the liability of over-rigid procedural formalities must prevail. Therefore, as long as default is established and limitation is satisfied, the proceeding cannot be dismissed just on the basis of formal clarifications of the pleadings. Honorable Bench, the appellant bank respectfully submits that the corporate debtor has been in uninterrupted default for over a decade, repeatedly just acknowledging its liability through multiple OTS proposals between 2017 to 2022, and again ultimately failing even on the sanctioned OTS. In the light of the Valal RCK case and internationally accepted insolvency standards, which emphasize substance form, the strategic revision of default date in the amended petition cannot prejudice the debtor, not defeat the proceeding. The essential truth remains unmistakable that the corporate debtor is unable to repay its due. Therefore, this honorable court is urged to recognize the revised date of default as a legitimate procedural refinement, not a clerical error, a refinement, and admit that Section 7 petition, in keeping with the objectives of the court and the global best practice in the corporate debt resolution. If the honorable bench is satisfied with the arguments, then the council would like to proceed with the prayer.
Yes, proceed.
Much obliged, honorable bench. Wherefore, in the light of the facts stated, issues raised, arguments advanced, and authorities cited, the counsels for the appellant humbly pray before the Honorable Court that it may set aside the impugned orders dated past by the Honorable National Company Law Tribunal, Indigo, as being erroneous in law and conflicting with the settled principles governing the IBC, hold and declare that the second application filed under Section 7 of IBC by the petitioner, the financial creditor, is maintainable in law, clarify and declare that the mentioning of the date of default in Section 7 application is directory in nature, declare that the date of default is a dynamic factual circumstance being dependent on the conduct and correspondence, direct the admission of the petitioner's application under Section 7 of IBC 2016 against the respondent, and uphold the corporate insolvency resolution process, and or may pass such other or further orders that this honorable court may deem fit and proper in facts and circumstances of the present case, in light of justice, equity, and good conscience, and for the act of kindness, the appellant as in duty bound shall ever pray. The council would like to state that it was an honor to argue before the honorable bench.
Good.
Thank you, honorable bench.
Yes.
we request your lordships and your ladyship. Would you like to discuss about the students marking now or after the entire round is over?
After subject to her leaderships.
Yes, after the entire round is over, that would be
Yes,
better, is it not?
yes, yes.
What do you say? Yes.
Yes.
Before I call on uh, the other side, I'll try to replace the spotlights, please.
Yes.
So we have TGA 7, is it? Yes.
Yes, sir.
And court master. So we request again the teams. Only if you're sharing a case law, please share screen. Do not share screen of your entire compendium. It would affect the recording process.
Try to be brief. Hmm?
Court master, can the respond?
Respondent speaker 1, you can now proceed.
May it please the court, the counsel seeks permission to address the bench as the honorable bench.
Yes.
Much obliged. Honorable bench, this is counsel 1 arguing on behalf of the respondent. The counsel would be taking 15 minutes of the court's time and deal with issue 1 and 2. And my co-counsel would be dealing with issue 3 and 4 and would be taking 15 minutes respectively. The counsel now seeks permission to explain the facts of the case in a brief manner. Much obliged. Honorable Bench, the respondent is a company incorporated in 2013 engaged in the energy sector and a borrower of rupees 500 crores from the appellant ABC Bank. The loan was duly disbursed and repayments were regular initially. However, like many corporate entities, the respondent later suffered several financial setbacks, the most crippling being the COVID-19 pandemic. Business halted, revenues collapsed, and insolvency filings across the country surged. Recognizing this, the Parliament introduced Section 10A, insulating pandemic period defaults from CIRP, Corporate Insolvency Resolution Proceedings. Through this period, the respondent never denied its liability. In fact, continuous OTS and restructuring proposals from 2014 up to 2022 demonstrating willingness to settle, not to evade the lordships. Even an OTS was sanctioned in 2020, but pandemic hardship frustrated completion. Despite this, on the Honorable Bench, the bank filed its first Section 7 application in 2022, declaring default as 1 May 2020, a date completely barred under Section 10A. Both NCLT and NCLAS dismissed it. The Honorable Bench attained finality. Yet, Honorable Bench, after losing twice, the bank returned in 2024, this time shifting the default date back to 2014, nearly a decade earlier. The same cause, only the dates rewritten to bypass the earlier dismissal. The NCLT and NCLAT, therefore, the Honorable Bench held that the bank cannot be permitted to change the default date after final order and that a second application on a default on a different factual foundation is barred by res judicata. If your lordships are satisfied with the facts, the council now seeks permission to begin with issue 1.
Yes.
Much obliged. Honorable Bench, issue 1 pertains to whether or not a second application under Section 7 is barred by law. To prove my arguments, the Honorable Bench, the Council would be relying on 3 limbs. A, that the second Section 7 application is barred by Section 10A of the IBC. B, that the second application is barred under Order 2, Rule 2 CPC and res judicata. And C, your lordships, that the acknowledgement by the corporate debtor does not create a fresh cause of action. Honorable Bench, coming on to the first limb, lordships, the financial creditor shift of the default date from 1 May 2020 in the first application to 1 April 2014 in the second application is an attempt to dodge the bar under Section 10A. The Section 10A, the Honorable Bench bars the filing of an application between the period of 25 March 2020 to 24 March 2021. Your Lordships, in the case of Ramesh Kaimal versus Siemens Gamesa Renewable Power Private Limited, if my the Honorable Judge permits, the researcher would be showing the compendium to illustrate the case.
What is the relevant provision of law for res judicata?
Miss Ladyship, the relevant provision for res judicata to be applicable is Section 11 of the CPC.
Yes.
Miss Ladyship, in this case, the Supreme Court held that the application for default occurring within the Section 10A period are non-maintainable and emphasized the detrimentive role of the current date of default. Hence, Lordships, the misdating the default is unacceptable. Section 10A imposes a permanent prohibition on filing for defaults during the protected period. The Honorable Bench, in the case of Gujarat Urja Vikas Nigam Limited versus Amit Gupta, the Supreme Court underscored that the court does not permit duplicative proceedings for the same cause. Your Lordships, in the present matter, the whole case is about the default date. The whole case is the same. Just the default date has been changed, and hence, Lordships, the res judicata clearly applies in the present matter. Lordship, the Honorable Bench, a default once pleaded and relied upon cannot be rewritten after judicial recognition. Honorable Bench, in the case of Rolta Private Limited versus Venenium Cloud Limited, the NCLAT held that merely because liability was granted to file a fresh application, the financial creditor cannot change the earlier admitted date of default for convenience. Honorable Bench, in this case as well, the appellant filed the first Section 7 application with 4 Feb 2021 as the default date. And after dismissal due to Section 10A, it cannot revise or shift the date to escape the earlier bar was held in this case, the Honorable Bench. The tribunal noted that creditor never sought an amendment in the first round and therefore cannot reopen or rewrite the default to create a fresh cause. The council lordships humbly submits that if the appellant wishes to actually change the date of the default, they could have done it through an amendment in the first application itself. Lordships, if I may refer to Section 7 Clause 5 of the IBC, if I may read it for the Honorable Bench, it has been mentioned, Lordships, the Honorable Bench, that under Section 7 Clause 5, it has been mentioned that provided that the educating authority shall, before rejecting the application under Clause B of subsection 5, give a notice to applicant to rectify the defect in his application within 7 days of receipt of such notice from the educating authority. The Honorable Bench, if the mentioned date of default was wrong, then before the matter went to the before the educating, before the matter, the Honorable Bench went to NCLT, and then there was an appeal to NCLAT as well. If the appellant knew that the date of default is wrong, the educating authority gives them a time period of 7 days to correct and rectify that date of default. It has been clearly mentioned under Section 7 Clause 5. It clearly shows that there has been a clear attempt on part of the appellant to dodge that bar under Section 10. To continue the Honorable Bench, the Council submits that a second application in the Section 7 of the IBC on the same debt and between the same party is legally impermissible. Order 2 Rule 2 CPC mandates that all reliefs arising from a single cause of action be claimed in one proceedings. The appellant cannot repackage the same claim in a subsequent petition without leave. The rule exists to prevent multiplicity and harassment. The appellant's refiling is a clear attempt to litigate the same debt twice. In the absence of any fresh cause of action, the second application stands barred. The earlier proceedings before the NCLT and NCLAT were dismissed and decided on merits, and any fresh attempt to revive the same claim amounts to relitigation. And hence, the doctrine of res judicata under Section 11 CPC applies to insolvency matter to prevent multiplicity and abuse. The Honorable Bench, the Supreme Court, in the case of KK Modi versus KN Modi, held that representation of the same dispute in the disguise of a new cause of action constitute an abuse of power.
The, 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 first,
Similarly, Honorable Bench,
the first round of
indeed,
litigation failed.
Indeed, Miss Ladyship.
The first round of litigation failed because of the fact that it was barred by Section 10A IBC. Then how can you say that it is an order passed on
Indeed,
merit?
Miss Ladyship.
It is not an order passed on
Miss
merit.
Ladyship, when an order Miss Ladyship, when an order is passed, it is a speaking order. And the court has actually analyzed the date of the default as the date of 1 May 2020. And hence, Miss Ladyship, the appellant contention that the date of default was a procedural defect was actually wrong, because the decision has been given on merits, keeping in mind that the date of default has been educated, and the appellant has not made any attempt to actually within that 7 days period to rectify that date and amend it. Hence, it is clear that the appellant knew that the date of the default is the date of 1 May 2020 and not the date that they have now mentioned in the second application, Ms. Leadership.
Yes.
Ms. Leadership, in our case as well, the financial creditor treated 1 May 2020 as the default date earlier. It is stopped from asserting a new one now, Ms. Leadership. The unclad in ABIX Singapore Private Limited versus Committee of Creditors of EDICOM held that the doctrine of res judicata is applicable to proceedings under IBC, and hence the Honorable Bench, it is clear that the second application is barred under Section 11 of CPC.
Yes.
Continuing the fact that acknowledgement of liability does not constitute a fresh cause of action. Honorable Bench, it is humbly submit that Section 7 application is clearly barred by limitation. In the case of Babulal Vardharji Gurjar versus Veer Gurjar Aluminium Industries, the Supreme Court has made it absolutely clear that limitation for a Section 7 application begins from the date of default, and this period cannot be kept alive by stray letters, emails, or repeated ODS proposals. Honorable Bench, it is respectfully submitted that unless the creditor specifically seeks continuation of delay under Section 5 of the Limitation Act, a time-barred debt cannot be revived. Likewise, the Honorable Bench, an acknowledgement under Section 18 can extend the period of limitation only when it is clearly pleaded, properly proved, and supported. Mere balance sheet entries or internal corporate records does not extend limitation unless these acknowledgements are expressly pleaded with the Section 7 application itself. In the present case, the applicant has themselves recorded the date of default as 1 April 2014. More than 3 years have passed since that date. No acknowledgement within that limitation period has been pleaded or produced. There has been no continuation of delay under Section 5 of the Limitation Act, which has been proved by the appellant in the present matter. Therefore, applying the ratio laid down in Babulal Vardharji Gurjar, this Section 7 application is hopelessly time barred and is not maintainable. Your Lordships, now coming on to issue 2. Issue 2 pertains to whether mentioning of the date of default is mandatory or not. To prove my arguments, Honorable Bench, the Council would be relying on two limbs. A, Form 1 statutory requirement mandates disclosure of default date, and non-compliance renders application incomplete. B, that the date of default is essential for maintainability and limitation. The Honorable Bench, under Rule 4 of IBBI Rule 2016, the financial creditor must file the application in Form 1, which specifically requires the amount to be claimed in default and the date on which the default occurred. Failure to state or misstate the date results in non-compliance with the statutory form and accordingly leads to an incomplete application under Section 7, Clause 5, Subclause B of the Code. If I may please, for the benefit of the court, mention that the grounds of the refusal of an application are mentioned in the 7 clause 5, and one of the ground mentioned is a ground of incomplete application. If the honorable bench, if there has been no mention of the date in form 1, the whole application would be incomplete, rendering it as a ground for the refusal of application in section 7 clause 5. Honorable bench, also under section 7 clause 2 of the IBC, an application must be submitted in the prescribed manner and form as may be specified. Honorable bench, in the present matter, the manner was specifically specified under form 1 part 4 of the and in rule 4 of the IBBI rules. However, that procedure has not been complied with, rendering it an incomplete application and a ground for refusal of an application. Honorable bench, coming on to the second leaf of my submission, it is submitted that the honorable bench that exact date of default is not a mere formal formal detail, but a determined factor for maintainability under IBC 2016 and limitation under the Limitation Act 1963. The honorable bench,
what is a default and what is a date of default? Is it defined under the IBC?
Indeed, Miss Ladyship, default has been clearly mentioned as a failure to pay when due under section 3 clause 12 of the IBC. And Miss Ladyship, what was the second question?
What is a default and what is a date of default? Is there a definition under the IBC regarding these two?
Miss Ladyship, the date of default has not been, Miss Ladyship, the default has been clearly mentioned in section 3 clause 12 of the IBC, and the default is the definition is the failure to pay when due. In the present matter, when there has been the failure to pay when due, hence Miss Ladyship, when talking about the present matter, after 2014 NPA, the corporate debtor actively negotiated restructuring and multiple OTS proposals every year from 2017 to 2022. If 2014 cannot be the date of the default, because there has been continuous continuous negotiations, restructures, and settlements offers. Hence, the date of default would be expressed as the default date when the amount became due and unpaid.
Yes.
Miss Ladyship, that's my humble submission.
I think your time is up.
Indeed, the honorable bench, both of my submissions are already submitted before this court. Now my co-counsel would be dealing with issue 3 and 4.
Yes.
Good.
Greetings to the bench. My lords, this is counsel number 2, and I'll be dealing with issue number 3 and 4. Issue number 3, Honorable Bench, states that whether or not the date of default changes based on the facts and circumstances, or it is to be taken as a date of NPA in all bank matters. Under this issue, bench, the council majorly have two submission that default under the IBC is a single objective factual event, not a variable or shifting concept. And the second submission would be the attempt to change the date of default from 1st May 2020 to 1st April 2014 is nullified and hit by res judicata. Coming to the first submission, my lords, the definition of default under section 3 clause 12 states that default means non-payment of debt when whole or any part of installment or installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor, as the case may be. The structure of this definition of the honorable bench is important. It speaks of a singular moment when the debt becomes due and is not paid. It does not envisage multiple defaults, altering default dates, or any flexibility where the creditor may choose convenient date depending on circumstances. The Supreme Court, the Honorable Supreme Court, has strongly affirmed this understanding in the landmark judgment of Innovative Industries Limited versus CCI Bank. The bench, it is a 2017 judgment. May refer to the compendium for the purpose. The court held that default is an objective fact, one that must be established on a particular date. The adjudicating authority's role is simply to see whether default has occurred, not whether it can be reconstructed, reinterpreted, or reshaped based on the events. Applied to the present facts, the Honorable Bench, the account was classified as NPA on 1st April 2014, but the OTS default was on 1st May 2020, which stood protection under Section 10A of IBC. That it is the only valid default date under Section 3 Clause 12 for that purpose. Any later mention of date, such as 2014 date, inserted afterwards, cannot replace or rewrite the default. Thus, in light of statutory text and binding precedent, default is a single factual event which is already established. This brings to the second submission under the same issue, that the attempt to change the date of default from 1st May 2020 to 1st April 2014 is nullified and hit by res judicata. Honorable Bench, the financial creditor is impermissibly attempting to relitigate a dismissed claim by altering the default date. I respectfully submit that this contention is wholly misconceived. The initial Section 7 application, which was filed in 1st Feb 2022, had mentioned the default date as 1st May 2020, a date falling within the COVID-19 protection, which barred initiation of a corporate insolvency resolution process for default occurring during the interval. The dismissal of that application was therefore on the account of a statutory bar under Section 10A. However, my lords, the correct date of default has always been uh, the 2020 date and was clearly consistently reflected in the financial creditor's earlier pleadings. The subsequent reference to the 2014 date, the alleged NPA date, was wrongly impleaded and is nothing but an afterthought introduced to overcome the bar of limitation and the protection granted under Section 10A of the IBC. The bench, this attempt to retrospectively shift the default from genuine 2020 date to a time bar 2014 date cannot be permitted. The financial creditor is bound by its original correct assertion of the 2020 date, and any later insertion of a 2014 date is erroneous, unsupported, and legally unattainable. I would rely on the appellants would rely on cases suggesting that a party cannot alter factual date of default to relitigate a rejected claim. However, my lords, the principle applies only where the originally pleaded default remains the same and applicant merely attempt to repackage the same default to avoid dismissal. This is not the situation, my lords. This brings to the humble submission of a judgment, Babulal Vardraj Gurjar versus Veer Gurjar Aluminium Industries Private Limited. My lords, is a 2020 landmark judgment. The Honorable Supreme Court has categorically held that the date of default originally pleaded forms the foundation of the cause of action under Section 7. And if no alternate date or acknowledgement was asserted in the application, the creditor cannot later attempt to modify or shift that default. The court emphasized that applicant must stand on its own pleadings and cannot build a completely new factual case at as the subsequent stage. The bench, Section 11 CPC and the doctrine of res judicata applies where an issue has directly and substantially decided earlier. The purported 2014 default was never a part of financial creditor's original case and never adjudicated in the prior petition. Therefore, it cannot now be projected as the true date of default to overcome a statutory bar. Introducing an entirely new and early date at this stage does not amount to clarification. It constitutes an improper attempt to reshape the cause of action. Bringing an incorrect date and an unpleaded date before this honorable court is not the exercise of a statutory right, but an abuse of process, as it seeks to substitute the creditor's own originally admitted default of 2020 with a fabricated earlier one. The only legitimate and legally recognized default date is 2020 default in 1st May 2020, and the financial creditor must be bound by it. This was the submission for issue number 3, my lords. Now the council will proceed with issue number 4, which states whether or not a case can be admitted if the default has occurred and the application is within limitation, despite an error in the date of default. An incorrect default date strikes at the root of maintainability under Section 7, Clause 5, Subclause A. Manipulation of default date, which is the second submission, undermines creditors' credibility and abuses the IBC process. Now, furthering the first submission, Lordship, it is submitted that under Section 7, Clause 5, Subclause A of IBC, this Honorable Adjudicating Authority can admit a Section 7 application only after being fully satisfied that a default has occurred. This statutory requirement is not a mere formality, it's a condition precedent to exercise jurisdiction. The tribunal must be able to pinpoint when the default occurred because limitation, accrual of cause of action, and very maintainability of the petition depends on it. If the date itself is misstated, inconsistent, or lacking in clarity, then this foundational fact becomes unreliable. And when the foundation is unreliable, the Honorable Bench statutory satisfaction mandated by Section 7, Subclause 5A simply cannot be arrived at. The tribunal cannot be expected to admit a petition where the basic factual premise, the date on which the debtor first failed to pay a due debt, is uncertain, shifting, or contradicted by the record. Accordingly, my lords, I submit that when the default date put forth by the financial creditor is inconsistent with statutory records or is later substituted by a wholly different date, the petition becomes non-maintainable. Unless the creditor furnishes a clear, consistent, and verifiable date of default, the requirement under Section 7, Subclause 5A remains unsatisfied and the application cannot be admitted. This brings to the second submission under this issue, which is manipulation of default date undermines creditor's credibility and abuses the IBC process. The Honorable Bench insolvency proceedings under Section 7 are among the most severe remedies available in commercial law. These proceedings are capable of displacing management, freezing assets, and triggering corporate death in the corporate institutions, my lords. Because of these extraordinary consequences, the application is held to be the highest standards of candor and accuracy. The financial creditor, however, has failed to meet this fundamental threshold. By asserting a default of 1 May 2020 and later shifting it to 1 April 2014, the creditor has manipulated the most material foundation fact. Such selective alteration is not a matter of mere procedural lapse. It reflects a serious breach of bona fides. The credibility of the entire petition becomes suspect when the applicant cannot even present a consistent factual basis for the event that triggers insolvency. To that, my lords, I would like to present a case SP Chenigara Varya Naidu versus Jagannath. May refer to the compendium. It is a 1994 judgment of the Supreme Court which held that a litigant seeking relief must approach the Honorable Court with clean hands. A party that conceals, distorts, or strategically reshapes the material fact forfeits the right to relief. Here, the shifting default narrative clearly violates this doctrine, my lords. The Honorable Bench, when the applicant manipulates the very fact that confers jurisdiction under Section 7, it not only erodes the forum's trust but also amounts to an abuse of the IBC mechanism. And such a petition tainted by lack of condor cannot be entertained. My lords, this was the submission from both the issues. Now the council seeks permission to move forward with the prayer.
Yes, proceed.
Wherefore, in the light of facts stated, issue raised, arguments advanced, and authorities cited, may this Honorable Supreme Court of Indigo be pleased to dismiss the civil petition, the civil appeal filed by appellant under Section 62 of the Insolvency and Bankruptcy Code, uphold the concurrent findings of Honorable NCLT and Honorable NCLAT, holding that Section 7 application is barred, declared that the appellant cannot alter or shift the date of default at its own convenience, and that such conduct renders the second application not maintainable. Affirm that the appellant's claim is barred by limitation as the alleged acknowledgements do not revive the time period of initial CIRP and are insufficient to overcome a statutory constraint and or pass any other order that it may deem fit in the interest of justice, equity, and good conscience, all of which is most humbly and respectfully submitted. Much obliged, bench. It was a pleasure arguing before this honorable court.
Good, good.
If the honorable bench permits, can we move on with the rebuttals?
Yes.
Much obliged, honorable bench. To this, the first rebuttal that I would be submitting is the respondents have been suggesting us amendments, also incorrect date of default, rectification of the application of res judicata. When times and again, me and my co-counsel have mentioned that it was an arbitrary cause for us to change the date of the second application. And also, we would like to confirm that this has happened because the respondents, they have not respected the payment of the OTS, which has led this failure to honor the OTS installments has led to the original debt to be actually revived, and thus we have applied for the second Section 7 application. And in no way do they have the same debt, because the previous one was pertaining to the OTS settlement, which is a settlement and not actual debt. And this one, they have to pay the original debt along with the interest amount. Further, I would put my second rebuttal as, are the council of the respondents suggesting that a temporary statutory bar under Section 10A creates a permanent extension of the creditor's right to their debt when like no evidentiary record of debt or default where actually subsists. There is subsistence of proper evidential record, yet they think that it does not subsist despite the merit of the default and the continuous default existing on their part. And they've also mentioned that they have willingness to settle, but for the period of 2014 to 2022, even on the fact when we had entitled them to repay it and we had given them 2 months of time, and since they might argue that from 2014 to 2020 they have constantly sent us letters, proposals, I'm not sure what the amount was, but it was definitely not as much as rupees 500 crores, and that is the sole reason we have not reverted. Much obliged, your lordship.
If my lords can get 1 minute to just rebut the point which is being stated.
Yes.
My lords, the OTS failure and the larger intent of the corporate data is being questioned. My lords, I would like to state that another OTS was sent in 2022. If the creditors were ready for settlement, they would have accepted that letter, but they simply moved forward with this application in 2022. Secondly, my lords, when they state that the default date and the structuring was arbitrary, my lords, that was a procedural requirement. Again, if they had error, they had a notice period time of 7 days and they would have rectified that error. But they didn't rectify that error, and they are coming all together with a new date, which is, my lords, erroneous and should be rejected. This was my humble submission. Much obliged.
Can
Your
a
lordship,
OTS be considered as acknowledgement?
Sorry, my lords.
Can the date of OTS can be considered acknowledgement?
Can be considered as a
Acknowledgement. Acknowledgement.
No, my lords. It is it is a date of default itself. It is not an acknowledgement, which is what the actual date of default has to be, which they are pleading as acknowledgement to further their limitation. This is what my submission is.
your lordship, if we were permitted to add on to this.
Yes.
Your lordship, as per Section 18 of the Limitations Act, as long as the debt subsists and also there is dual relationship between the parties and written acknowledgement, there is to be proven fact that the limitation period subsists. And also for the sheer fact that council has been mentioning that it is erroneous date, it is not at all an erroneous date. It is the second application which is based on a different entirely date and a different debt amount on a whole.
Honorable bench, can I answer this in just a sentence? Honorable bench, it is really important to know that just relying on OTS cannot be treated as an acknowledgement. I mentioned in my arguments also that an acknowledgement need to be pleaded and there should be a continuation of delay. The Article 137 of the Limitation Act clearly mentioned the time bar period of 3 years. Now, Miss Ladyship and your lordships, if your lordships, the acknowledgement need to be pleaded, and under Section 5 of the Limitation Act, there is a continuation of delay, which state that for a time bar debt to be revived, there should be an application filed along with Section 7, and hence that has been not been done. So if the acknowledgement is not pleaded before this honorable court, then how an OTS could be treated as an acknowledgement is my question.
Yes. Madam.
Sir and ma'am, with your permission, would you like to give feedback to the students? If ma'am and sir, your
No, we'll address in the valedictory session.
yes. On that note, we would hold that the session for the final rounds is completed. Uh, Coordinator, please put all the participants in the waiting room and we'll open the breakout room for discussion for the honorable judges.
Yes, sir.
ಏನಮ್ಮ
Thank you so much, Your Lordship.
Yes, sir. He's not here. I'm here. Oh, I'm not there.
We'll just spotlight people. Uh, Shubhra Singh, please switch on sir's camera. Yeah. Spotlight. Uh, with your permissions, your ladyship and lordship, can we commence?
Yes, you can commence.
With your leadership and with your lordship's permission, can we start? A very good evening to everybody. On behalf of Thomas George and Associates and the entire organizing committee, I extend a warm and respectful welcome to everybody present here for the valedictory ceremony of the 6th Thomas George and Associates Virtual Moot Court Competition 2025. After intense arguments, rigorous research, and exceptional advocacy, we have finally reached this moment of celebration, reflection, and recognition. Today is not only about conferring about awards, but about honoring the spirit of learning, perseverance, and excellence that each participant has brought to this year's edition of the competition. It is now my privilege to invite our esteemed dignitaries for this evening for this valedictory session. We begin by inviting Advocate Thomas George Sir, a visionary leader, mentor to generations of young lawyers, and the driving force behind this entire initiative as the founder and managing partner of Thomas George and Associates. Advocate Thomas George Sir is the founder and managing partner of Thomas George and Associates. He pursued his passion for law, for wanting to follow the footsteps of his cousin, who was a barrister, and he completed his studies in law, thereby entering a completely new profession. The firm was founded by him in the year 1998, and since then it has dealt with several kinds of litigation and non-litigation work. Every development in the firm has its constant efforts that the firm is grateful for. The firm has its base in Hyderabad, dealing with a range of subjects, including that of corporate law, civil criminal law, taxation, intellectual property rights, consumer laws, and other allied laws, matrimonial laws, property, and other laws, including arbitration. Since the establishment of the firm, Advocate Thomas George Sir has represented the firm in a plethora number of cases before the Honorable Supreme Court, various high courts, other district courts, tribunals, and other quasi judicial authorities. He believes in settling matters amicably through negotiation and mediation to resolve them quickly. Sir, your steadfast commitment to legal education and your passion for nurturing us young law students under your constant support are the main pillars for ensuring that this competition is possible year after year. I now request Advocate Thomas George Sir to please deliver his welcome address.
Thank you, Mr. Rahul. Good evening, one and all. Most respected Honorable Justice Suryapalli Nanda Garu, Honorable Justice Gade Praveen Kumar Garu, Designated Advocate Sri L. Ravichandra Garu, Deepak Bhattacharya Garu, Dr. Venkat Reddy Donde Reddy Garu, Madam Nirmala Garu, Advocate Manav Jasil Thomas, the backbone and pillar of this moot competition. A warm welcome to one and all for the 6th moot court competition hosted by Thomas George and Associates. Dr. Johnson once observed, the law is the last result of human wisdom acting upon human experience for benefit of public. And again, another anonymous quote, every man have justice at another man's expense, which is apt for the moot subject of today. I hope you will agree, because the bank, the corporate debtor, and the corporate creditor both they were fighting tooth and nail. But end of the day, it is the cost of someone else's expenses, that is a corporate creditor. Anyway, I am pausing at that. We are indeed grateful to all the judges and the designated senior advocates who have been always ready to help us conduct the moot competition successfully. A big thanks to one and all, especially our judges, who have made this sixth moot court competition a very successful one. And at the finals, now I know all are eagerly waiting to know the results, but I must add and tell you, every year the performance has been going from good to better to best to excellent. Now, this time's competition, because of the subject chosen, is the fever of the young generation. And we, keeping in mind, decided to choose this IBC law. And it was tremendously well accepted. And it was, all the judges was finding difficult right from the prelims to here to uh, judge the competition, because all were tooth and nail. They were very well presented. I appreciate the efforts put in by the students, and I also appreciate the colleges and the faculties molding and training the students to come out with this great quality in the field of law. A big thanks to one and all. And I also say we can be proud that the legal legacy is in the right, vibrant future generation, which we can be proud of. And this can be very confident. We can look confidently for the future generation. And our country will be going to much higher level. I'm confident that the young generation, the vibrant generation, is very conscious of the developments happening, and they're abreast of the situations of the country and the corporate world. With these few words, I conclude, and I know all of you are eagerly waiting to know the result. I am handing over the floor back to you, Mr. Rahul. Thank you very much. Thank you very much.
Thank you so much for your wise words, sir. It is now an immense honor to invite our first judge of the final rounds, Honorable Mrs. Justice Surapalli Nanda ma'am, Judge of the Telangana High Court. Honorable Mrs. Surapalli, Honorable Justice Surapalli Nanda ma'am enrolled as an advocate on the rolls of the Bar Council of Andhra Pradesh in the year 1993. After her enrollment as an advocate, her ladyship joined the office of Honorable Justice G. Chandraya Garu as an advocate, and later worked as a junior counsel assisting V. Rajagopal Reddy Garu, senior advocate. Her ladyship has actively practiced for nearly 3 decades at the High Court of Judicature at Hyderabad, and dealt with all types of constitutional, civil, criminal, labor, revenue, service-related matters, and she specializes in the area of writs. Ma'am has constantly engaged in pro bono work for the Legal Service Authority and has worked as a panel advocate for the AP State Legal Service Authority in the High Court of AP, and continued as such till her elevation as a judge of the High Court of Telangana. Ma'am has also held the assignment of master trainer to train the legal aid panel lawyers of all the districts of Telangana on advancing of lawyering skills, along with 2 other court master trainers. Prior to her elevation, Honorable Justice Surapalli Nanda ma'am has held several key positions, including that of the Standing Counsel for the Bar Council of India in the year 2006, and she's continued as such till the elevation as a judge of the High Court of Telangana. She has worked as the assistant government pleader for the Panchayat Raj, worked as assistant government pleader for land acquisition, worked as a reporter, Indian Law Reports, Law Journal of High Court of Andhra Pradesh, appointed as Central Government Counsel dealing with all cases pertaining to external affairs, mines, home affairs, customs, and central excise, etc. Appointed as a panel advocate, Government Counsel to represent Union of India in cases relating to that of grant of Central Samman Pension, a legal advisor to Nizam's Institute of Medical Sciences, a panel advocate for the Corporation Bank and the Oriental Bank of Commerce, appointed as a member in the Enquiry Committee to inquire into the complaint regarding the alleged indecent representation of a woman IS officer. She was also the standing counsel for the National Institute of Rural Development and Panchayati Raj. She's dealt with cases on behalf of Petroleum and Natural Gas Regulatory Board, New Delhi, as a special counsel. She was also the member of the Institutional Ethics Committee of Medical and Health Research Institute, Maternal Health Research Trust. She is a legal expert for the NRI Women's Safety Cell, Women's Safety Wing, Telangana. She is a member of the High Court Gender Sensitization and Internal Complaints Committee. She was a panel advocate for the National Commission of Women, Delhi. With effect from 15th April of 2021, her ladyship was designated as a senior counsel and is the first woman to have been designated as a senior advocate after the establishment of the state of Telangana. There are more than 64 reported judgments reported in various law journals in which ma'am has dealt with as an advocate. Honorable Justice Suripalli Nanda ma'am has been elevated and sworn in as a permanent judge of the High Court of the state of Telangana, and her ladyship has authored more than 640 reported judgments and has acquired extensive experience in dispensing justice at the High Court of Telangana. Ma'am is a member of Commonwealth Magistrates and Judges Association, London, and the International Association of Women Judges, Washington, D.C., USA. Her ladyship is also the first judge from Telangana and Andhra Pradesh High Courts to have pronounced separate judgments in 76 cases on a single day when the High Court reopened after summer vacation. Her ladyship has been the recipient of several awards such as Acharya Chanakya Sadbhavam Puraskar Award, the Elders Club Excellence Award, the National Unity Award by the Telangana Citizens Council. We are privileged and honored to have your ladyship to join us on this occasion today. Honorable Justice Suripalli Nanda ma'am career has been nothing short of an inspiration for us young law students. May I request her ladyship to kindly address the gathering?
Address the gathering or announce the result?
Address the gathering, ma'am.
Addressing thereafter results. Let there be suspense.
Your ladyship and your lordship, the results will be after the vote of thanks. After that, we request.
Yes.
So first,
Yes.
your speeches, and we would like that to happen, and then a vote of thanks, and after that, we can come back to declaration of results. Thank you.
Very good evening to one and all. Respected colleague, Honorable Justice Gadi Praveen Kumar Garu, respected Senior Advocate Thomas George Garu, respected Senior Advocate DC Nirmala Garu, respected Senior Designate Counsel Sri L. Ravichandra Garu, Deepak Bhattacharya Garu, D. Venkat Reddy Garu, Mr. Manav, and all the students who are here for the valedictory session, all the students who have participated in this Moot Court Competition 2025 organized by the Thomas George and Associates firm, and all who are watching online. I'm happy to be part of this momentous event. As a judge in the virtual Moot Court Competition 2025, along with my esteemed colleague Gadi Praveen Kumar Garu, one of the most appropriate and novel methods of imparting legal education is the concept of clinical legal education. Like an engineer or a doctor, a lawyer too needs to get practical training in order to serve the society to the best of his or her capacity and capability. Moot courts today have become an integral part of legal education. They bridge the gap between theory and practice of law and enable the prospective entrants to the bar to equip themselves with the basic requirement of the court craft and court culture. Knowledge without practical learning is fire without light. Such competitions prune the natural abilities of the budding lawyers like natural plants. Ed Howe stated very aptly, a theory is no more like fact than a photograph is like a person. Practice makes one perfect, and with lawyers, it is most likely to make them rich as well. I am of the firm belief that moot court competitions foster confidence, promote teamwork, and refine public speaking abilities, which are essential attributes whether you want to become an aspiring advocate whether you want to become a member of the judiciary or you want to remain as an academician. Dear students, the Moot Court competition, therefore, is a unique opportunity to learn under supervision, to enable you to think and act like a lawyer. It would help you to understand the legal profession and the lawyering process more effectively and to get acquainted with the art of researching on a given problem and imbibe the ability to master the facts, skills of drafting and arguing the case by application of law. Young friends, I congratulate you all for having chosen a promising career and shall be glad to share a few practical tips which may go a long way while you enter the portals of court. The first and the foremost, never cease to be a student. We, the lawyers as well as the judges, are eternal students of law. A degree in law merely gives us a platform to stand on and begin the journey. Law is never static. It is rather an ever-changing, vast and complex subject. Always keep abreast of the latest legal position. Master the facts and do your homework meticulously. Language is the dress of thought, and words are the most powerful drug used by mankind. Have a good vocabulary and use it well and carefully. Mark Twain emphatically stated, the difference between the almost right word and the right word is really a large matter. It is the difference between the lightning bug and the lightning. To understand others and be understood by all, know the big words, but always use the small ones. Don't get carried away by the sound of your own voice. Be brief. Brevity, as Shakespeare said, is the soul of wit. Let your argument be short, comprehending much in few words. Be punctual. A lawyer who is available to the court and to his client is a great asset. Be sincere and never ever change your sincerity. It is difficult but not impossible to conduct strictly honest business. An advocate is the officer of the court and must make an endeavor to maintain the dignity of the court, to assist in the case of justice without ever creating any obstruction. Therein should be your primary duty. Never be afraid of the competitors out there. Competition bring out the best in people. Don't let initial failures intimidate you. Fight a good fight and never be in an undue haste. Be patient. Remember, there is always room at the top. The road to success is always under construction. There are no shortcuts if you want to reach the promised land. You must go through the wilderness. Resolve to take fate by the throat and shake a living out of her. But none of the secrets of success shall work unless you do. If you have talent and work hard and long, anything in the world can be yours. Dedication to profession, hard work, integrity, candidness with the client combined with pleasing manners, fluency of language, ready wit, courtroom tactics, patience and confidence, and boldness make a successful lawyer. A law student must read the entire judgment minutely and should not make any opinion by just looking at the title. An interdisciplinary extensive reading is also a prerequisite for becoming a successful lawyer. A lawyer must first of all be a cultured human being. Lawyers should draft sound propositions. Legal profession is a service-oriented profession, and it is a lawyer's duty to lead the clients to the channels of wisdom. My elderly advice to all who are ready to take the big plunge is adhere to truth and uphold dharma, justice, and rule of law. Perform duty without aspiring for material gains and leave the result to God Almighty. During your academic studies, you would have encountered the law through the black letters of your books and case materials. However, when you enter the legal profession, you realize that law throbs with human interest. For law's concern is affairs of people. Laws breathe life in our minds and expect us to behave in a civilized manner with respect to everyone. Law is a communal enterprise based on order and procedure. It binds us together in mutual interest, mutual welfare, and mutual happiness. However, laws can only do so much until all of us are willing to participate in its endeavor. A law is not an antidote to prevalent social mores. Rather, it is a means to forge a new future based on the ideals enshrined in our Constitution. Law in itself cannot solve the human problems. Law is merely a set of facilitative tools to render justice. The general notion that is often ascribed to my role as a judge of the High Court is that I deliver justice. However, as students of law, all of you are also capable of rendering justice in your own small but significant way. It is incumbent upon you to endeavor to leave the law a little better than you found it to be. The theoretical underpinning of my suggestion is grounded in the fundamental idea of justice, which is essentially the constant and perpetual purpose of rendering each person their due in light of the social circumstances. We live in a society governed by rule of law. Rule of law, if understood and implemented properly, is a defense against oppressive structures such as patriarchy, casteism. It is an aspirational goal which is beyond you and me as individuals, but towards which all of us have our parts to play. However, we must understand that rule of law does not depend merely on the constitution or legislations. It largely depends upon the political culture and habits of citizens, especially young legal professionals like you. In a, in a sense, all of you are the guardians of our constitutional and democratic traditions. You must strive to make the legal profession more inclusive and accessible when you become a part of it. This is one way to further the goals of justice. If you are working in a corporate law firm, you must strive for a reasonably successful career. Every individual, irrespective of the individual differences, should strive for the success of the law firm. If you are a practicing lawyer, you have a professional responsibility to work for expanding access to justice beyond those who have financial or social advantages. If you aspire to join the judiciary, it is necessary that you place substantial justice as the foremost goal of adjudication. As a policymaker, you can devise policies to socially and politically empower the marginalized. As you make your way through this profession, don't shy away from trusting your judgment, even when the path ahead seems unclear. Tough decisions may lead to unexpected outcomes, but they are ours to own. Markers of a good law student have become endemic to your generation, with many even opening enterprises to profit from the eagerness of students to succeed in law school. But today, I urge you to leave the path of predetermined outcomes and give life a chance. The beauty of life is in its excitement and sometimes uncertainty. Trust your instincts and work towards whatever makes you happy. As the famous author Ralph Waldo Emerson once said, and I quote, "Trust thyself, every heart vibrates to that iron string. Nothing is at last sacred but the integrity of your own mind." Justice Sonia Sotomayor of the United States Supreme Court once said, and I quote, "I would hope that a wise Latina woman with the richness of her experiences would more often than not reach a better conclusion than a man who hasn't lived that life," unquote. Your unique perspectives shaped by your individual experiences are invaluable. Don't be afraid to bring them to the table, even when they differ from the mainstream view. As you move forward in your careers, strive to be not just great minds, but also compassionate human beings. As James Joyce, famous Irish novelist and poet, said, and I quote, "To learn, one must be humble, but life is the great teacher. Humility achieved through failures and experiences teaches us to preserve and grow." You all are not just law students, you are future decision makers, change makers, and future shapers. The world awaits your brilliance. Make it count, make it matter, and most importantly, make it yours. The law awaits you, and society needs you, not just as lawyers, but as ethical, empathetic, and dedicated defenders of justice. I wish all the very best to all the students in all your future endeavors. Thank you, one and all, for the patient hearing. I wish all the very best for you. All the students performed very well. They put in a lot of effort and they were well versed with the facts. well versed with the case law. I wish all the very best. Remain focused. There is no shortcut for success. There is no substitute for hard work. Wish you all the very best.
Thank you so much for your kind words, ma'am. We are equally honored to have among us Honorable Justice Kadi Praveen Kumar sir, Judge of the Telangana High Court, as our second judge for the final rounds today. Honorable Justice Gadi Praveen Garu is widely respected for his integrity, sharp legal reasoning, and his contributions to multiple branches of public law. He enrolled as an advocate with the Bar Council of the then Andhra Pradesh High Court. He initially joined the chambers of Sri Jitendra Rao and Sri A. Lakshmi Narayana Reddy advocates at Warangal trial courts, and later he joined the office of the then senior counsel Sri A.K. Jayaprakash Rao, advocate at the High Court, and gained substantial experience to various branches of public law. He actively practiced in the areas of constitutional law, civil law, criminal law, labor law, service law, and family matters. He served as a standing counsel for the Enforcement Directorate, a department of the Government of India, Armed Forces Tribunal, Security Printing Press, National Institute of Nutrition, and other central government departments covering various branches of law. His lordship has practiced for nearly 3 decades in various areas, and he was appointed as a central government standing counsel in 2015, wherein he served the department in this capacity. He also held the position of a senior standing counsel for the central government. Later, in October 2022, his lordship was appointed as the Deputy Solicitor General for India to the High Court of the state of Telangana, and he served various ministries of the central government until he was elevated as an additional judge of the High Court for the state of Telangana. He has been appointed as an additional judge for the High Court of the state of Telangana and has assumed charge on July 31, 2025. Your Lordship, your presence here encourages every participant who aspires to serve the legal system with intellect, discipline, and concise. We now respectfully invite His Lordship, Honorable Justice Praveen Kumar sir, to share his thoughts with our participants.
Thank you, Rahul. Most respected my senior colleague, Justice Honorable Justice Nanda Garu, and Senior Advocate Sri Thomas Judge Garu, and Madam Nagula Garu, and charming Manav Thomas. Really happy to see you all. You regularly appear in our bench and my personal single bench also. Indeed, we speak with our senior colleague, Madam. See how a son is accepting a father and a son is presenting before the court. How a father is feeling proud. That's what the growth, it's all greatness to your beloved parents. And it's indeed, it's a good opportunity for me also. And almost all the points which are covered by my senior colleague, madam, and nothing remains for me. But only thing, the advocates, we are all social engineers. In continuation with madam speech, what he said, we have a lot of responsibility to the society and the nation. Apart from all, we are representing the respective clients, we're representing the department, we are stepping into the shoes of our client. Still, we owe the responsibility at large. If our client is wrong, we can guide them. Even if we go on the road also, we should not be equated with others because should be in the right track only. And apart from this, in fact, Mr. Manav is into the social responsibility because you are building the future generation. The courage, development, and the professional skills. All the students are very happy to see it's engaged. I think they are one or the second year, third year they are pursuing. Even we go back to our 90s, so much of exposure we don't have. But now we are taking everything at advantage of it and moot courts, participation, and it gives a lot of courage to the future generations. The other one is the first is the clarity of thought and clarity of communication. I have observed almost all the councils today, and I was not the part of earlier. And the council should have a even judges also should have a sense of deep listening to the council, listening to the client, what is his briefs, and listen to bench. And in today's course, one of the I observed, he is not listening. He is not listening. He should. Madam is posing some question, and he should completely listen. Thereafter, understand. Then react to the question of the bench. And the other important is integrity to profession, integrity to the nation. That is the strongest asset. And happy to be among you all. And being a council, it's always agreeing apart from madam. It's always learning. My senior used to say you have three stages in your legal profession. One is entering, one is learning, and second is earning and learning. Third is learning. Third is only earning. But we say in continuation with madam, we always learn. Till we die, we have to learn ourselves. And as a counsel, you can be a counselor, or you can be a good advocate, or you can be a judge, or you can be a leader, you can be a politician, you can be a president of India. All or you can take inspirations from our past. And even in my research associate has taken 3 judgments in my short tenure. Sir, how much you saw the concern for the society. And while madam, my senior bench partner, Honorable Justice Musami Chatterjee, as Bhattacharya, given me opportunity to every week about 3 to 4 judgments I write. So only 3 judgments my research associates has picked up. And I would like to, I'm happy to share with you one of the, while writing the judgment on the prevent to detention in the matter of petition number 12443 of 2025, where one lady was involved in narcotic drugs. So while addressing the issue, what is I have addressed that the public health and safety forms is an essential part of the constitutional version under Article 21 and 47 of Constitution of India. The wealth of the nation ultimately depends upon the health of well-being of its citizens. So why this I'm quoting is our responsibility towards the society. And the second one is while addressing a judgment, sailing the local award. So a son fights against the father for a property issue. So where I have observed that we further observe that even assume the contention, so and so, we are unable to appreciate the conduct of the petitioner in fighting against his father. The responsibility of a son towards his father must be by sharing all the duties of each other, more particularly, son is duty bound to respect and look after the welfare and well-being of the parents. Considering the facts and circumstances, this court is a view check and and other finally, my research associate taken with respect to the marriage, while addressing a case in family court, marriage especially emphasize indivisible nature, which is sacrament, a holy union between the man and woman, intended to lead the life by supporting each other in joy and diversity. It is regarded as a holy sanskar, symbolizing a eternal bond and companionship, duty and a mutual respect between husband and wife. The institution of marriage is considered to be a very foundation of a family life and social stability, wherein not only the spouses but also families and future generations is bound together in them. So these are all why this quote is: we are all duty bound for society and nation at large. All of you, you're doing very extremely well. I congratulate you and each one of you to strength, wisdom, and courage in your entire journey ahead, and argue fearlessly, be responsible. Thank you. Thank you all.
Thank you so much for your wise words, sir. I would now like to invite Advocate Manav Jason Thomas, sir, Senior Member of Thomas George and Associates, to address the gathering. Sir is a senior member at Thomas George and Associates and is a budding lawyer. He joined the firm right after graduating from ILS Law College, Pune in 2015. His area of work encompasses litigation in various areas, including that of civil, criminal, labor, administrative, banking, personal, and other business laws. He handles uh, several litigations and non-litigation works at the firm. We request Sir to please share his thoughts with our participants regarding this competition.
Good evening to Honorable Justice Suryapalli Nanda ma'am, Honorable Justice G. Praveen Kumar sir, my fellow members at the firm, the Moot coordinators, the court masters, and the participants. A very good evening to all of you. It has been an honor and a pleasure to hear from Her Ladyship and His Lordship as to how one must conduct oneself into a journey of success. That is what I have taken from their respective speeches. Law is not a trade, not briefs, not merchandise, and so the heaven of commercial competition should not vulgarize the legal profession. The above quote was said by Honorable Justice V.R. Krishnayar, sir. The endeavor of our law firm in conducting this virtual moot court competitions is to nurture law students so that they come forward before the courts of law understanding the real time practice. The only grievance that law students have is there is a huge gap between theory and practice. For instance, if you ask any law student, what is a wakalat? What is a welfare stamp? What is a court stamp? Nobody knows what it is. So this gap has to be bridged. And with that endeavor, we have started this virtual moot court competition. Though we are a law firm with matters on a day-to-day basis, I as a law student passing out from ILS Pune from 2010 to 15 was my law school days, where I always and every time, every year participated in different moot courts. And because of that, I was able to present my cases before different courts of law, including His Lordship, including Her Ladyship, and received accolades from different benches. I'm proud of that. And that is why we have started this moot court competition so that students learn how they should present their case. The virtual moot court competitions we started in 2020 during the COVID pandemic, when one night I was sleeping and at 2 a.m. I got up and thought, why not during this free time I take it out and start virtual internships and virtual moot court for students. And we were so lucky, I must say, over this span of 10 years of my standing at the bar, we as a law firm gave virtual and non-virtual internships to 700 plus law students. We can proudly say that all of them will go to court with some practical experience in life. In today's era, litigation is heavily undermined and only corporate law firms are given a preference to. Trial advocacy and litigation is considered as the, I must say, a weaker section of the society by law students. And the only reason that law students consider litigation or do not choose litigation is because of the low pay that is there in the profession. To all the students, I would like to make only one fervent request, that is, do not choose your profession based on money. Choose your profession based on passion, because the only example for litigation is it is like a plant. You sow a seed today and it will grow into a great mango tree, giving you fruits after some years. Your lives as law students, when you'll enter the profession of litigation, you will earn maybe nothing. Then you will earn 3,000, 5,000. Then you might earn in lakhs. Then later on, people will only, like Sir said, there is only earning and then there is only learning. So there is another profession quote where lawyers say there are four levels in the life of a lawyer. One is there is no work and no money. Then there is little work and no money. Then there is little work, little money. Then there is more money and no work. So, in this background, I would say money should never be the element for why you choose any field, let it be litigation, judiciary, academia, or any other field of law. Let it be your passion that you come forward in any field of law. So before I end my speech, I would like to give few of the important facets of a litigating lawyer, which I would summarize in four words: dedication, perseverance, hard work, and passion. If you have all this, money and fame will automatically follow to you all. And the lives of our honorable justices sitting in today's ceremony are a testimony to these four pointers which I have given you all. Day in and day out, they sit and hear matters in the court, and they sit late night preparing judgments and uploading them. I had the opportunity in one of the vacation benches to see Her Ladyship call out my matter at 9:15 p.m. and sat on bench till 10:30 p.m. and then proceeded to upload and give judgments on the same day. Similarly, His Lordship in the division bench that Sir sits uploads the orders on the same day with an effect and an attempt that they are uploaded before they leave the court. With these examples that we see, we all must imbibe in ourselves that there is no success without hard work. There is no shortcut to money. Otherwise, like these monetary frauds, we will attempt on some shortcuts and we will only fail. Without taking any more time, I will yield the floor to the coordinator to call forward our senior member PC Nirmala ma'am for her vote of thanks, and then we can proceed for results declaration. Thank you so much to one and all.
Indeed, sir, those were some really inspiring and encouraging words for us law students. I would now like to call upon Advocate P.C. Nirmala ma'am to deliver her vote of thanks. Advocate P.C. Nirmala ma'am is a senior member at Thomas George and Associates, who is the driving force behind the firm. She has held various positions, including that of a lecturer, associate professor, head of department, academic dean, and control of examination, and has retired from the reputed women's college, St. Francis College for Women, after 35 years of unwavering dedication. Pursuant to this, ma'am went on to pursue law as a career, and she currently represents the firms in matters ranging from the Honorable Supreme Court, Honorable High Courts, debt recovery tribunals, consumer forums, family courts, and other civil and criminal courts. She intends to utilize her vast experience across academia and education to cater to the needs of society by uplifting the downtrodden and unprivileged, promoting environmental awareness, and empowering women. She is a true example to us young law students of how age is just a number and how hard work is actually the key. Is the actual key. I now request ma'am to please deliver her vote of thanks.
Thank you, Rahul. Good evening, one and all. We are honored and obliged, Honorable Justice Suriprananda Madam and Honorable Justice Gadi Praveen Garu, to having graced the occasion of valedictory program and also judging our final competition. Any event will be incomplete if we do not express a sense of gratitude to the event, to the people who have contributed, who have put in a lot of efforts to the success of this program. In fact, all of you students, law students, have heard a lot from yesterday, starting from retired Justice Kurian Joseph Sir of Supreme Court. I would like to just make a mention, two sentences. The legal profession provides an opportunity every day to learn, grow, and make a difference in the lives of others. A lawyer's profession is to uphold justice and protect the rights of individuals. This happens only if you are a litigation lawyer, and it's a very long, long journey. It took 20 years for Advocate Thomas George Sir to reach this level. He had come from Kerala to Hyderabad without knowing the knowledge, without having any godfathers. He set up this office with only passion and perseverance had led to the formation of Thomas Jones and Associates. I would like to thank, on behalf of Thomas Jones and Associates, myself, Mrs. Nirmala Thomas, profoundly thank our esteemed chief guest of 6th TGA Virtual Moot Court Competition 2025, the topic being Insolvency and Bankruptcy Code 2016. Retired Supreme Court Justice Kurian Joseph Sir had graced the occasion, and he had shared his valuable words of wisdom, knowledge, and experience to all our young budding lawyers. A special thank you to all our revered panel of judges of our finals, semi-finals, quarter-finals, and prelim rounds of 6th TGA Virtual Moot Court Competition 2025, whose insightful questions and thoughtful critiques elevated the entire competition and guided our future advocates. Today, this year, we had two sitting judges from the Honorable High Court of Telangana, Honorable Justice Mrs. Suripalli Nanda Madam, and Honorable Justice Sri Gadi Praveen Kumar Sir as judges of our final rounds. We had in our semi-final rounds all senior advocates, Senior Advocate L. Ravichandra Sir, Senior Advocate Deepak Bhattacharya Sir, Senior Advocate Dr. Venkat Reddy Dontireddy Sir, and Advocate Thomas George, founder of Thomas George and Associates. We had about 8 advocates who were judges for quarter-final rounds. Advocate Dr. Suripalli Prashant, Advocate Sagar Suri, myself, Advocate P.C. Nirmala, Advocate Manu Jessel Thomas, Advocate A. Satyasri, Advocate Rishabh Garg, Advocate Mrudulika Concepta, and Advocate Daniel George. And we had all advocates, in fact, 19 advocates for our prelim rounds. We had Danisha Vakati, Abhishek Roy, Shreya Vijayakumar, Devashish Tiwari, Shubhra Singh, Ritik Shekhar Srivastava, Krishna Chaitanya, Richa Joshua, Naganathan Iyer, Chaitanya Shil Priyadarshi, Anjali Nishtala, Tejasvi Reddy, Vidya Vincent, Tanvi Jain, Dr. Neha Handa Malhotra, Divya Nalla, Anuya Vaisarasu, Harish Chaudhary, and Asmit Agarwal. We thank all the judges of our various rounds, as I mentioned. And I would like to we are also immensely grateful to our respected founder, Advocate Thomas George Sir, Senior Member of TGA, Advocate Manu Jessel Thomas, and all associates of TGA, Advocate Shubhra Singh, Advocate Harish Chaudhary, and Advocate Anuya Vaisarsu, the Moot Court coordinators, Rahul Jacob and Aditya Bura, for their unwavering support, guidance, and tireless efforts in preparing the teams. Thanks to all the 19 volunteers who interned with us at various points of time, and they have provided the various courtrooms. In fact, we had 18 courtrooms in the prelim rounds. We had 4 courtrooms in the quarterfinal rounds. We had 2 courtrooms in the semi-final rounds and 1 courtroom in the final round. In fact, we thank all our brilliant participants and teams. Your passion, meticulous research, and impressive courtroom presence were truly commendable. You showcased the future of advocacy, and your dedication made this event a resounding success. We had participants from various national law schools and law colleges from different parts of India. We appreciate their enthusiasm and efforts put by all of them as applicants and respondents in the 6th TGA Virtual Moot Court Competition 2025. We also saw their patience and energy in the rapid researchers round, eagerly waiting to answer the questions put forth to them. We had altogether 36 teams participating in this moot court competition, and each team had two speakers and a researcher. This moot court is more than a competition. It is a platform for learning, honing skills, and upholding the ideals of justice. As we conclude, Thomas George and Associates encourages all of you young lawyers to carry forward the spirit of rigorous advocacy and ethical practice. Thank you all once again for being a part of this memorable event. We wish everyone success in the future legal careers. Thank you once again.
Thank you so much, ma'am. I would now like to hand over the floor to Advocate Manav Desai Thomas, sir, for the most
Now,
awaited part of the entire event.
so before we have the declaration of results, so her ladyship will be declaring three results: the best team, the runners up, and the best speaker from preliminary rounds. And his lordship will be declaring two winners, which will be the best memorial and the best researcher. Yes, ma'am.
Yes, I would like to add, with your permission, your lordships, that we have best team. The award is rupees 20,000. Runner up, the award is rupees 10,000 cash. Best speaker from the prelim round, rupees 5,000 cash. Best memorial, rupees 5,000 cash. And best researcher, rupees 5,000 cash.
Now I call upon Honorable Justice Nanda ma'am to come forward for declaring the results.
Best team TGA 18 from Amity Law School, Kolkata. Runners up TGA 80 from Christ University, Bangalore. Best speaker from preliminary rounds TGA 7 speaker 2 Sarthak Mishra from Christ University, Bangalore.
Now I would like to call forward His Lordship for declaring the results.
Best Memorial, TGA 20, Alliance School of Law, Bangalore. And Best Research Award, TGA 18, Amity Law School, Kolkata. Congratulations, all the best.
We thank you, judges, for declaring the results. We only request 2 minutes so that we have a group photo with all the members and the winners. First, we'll have a photo with our team. Yes, sir, you would like to say something? Sir, you need to unmute, sir.
I also wanted to add, there are books which is gifted by the Gogya Law Agency, and also we are giving trophies and certificates to all the participants and volunteers. All those things also may be announced.
Hearty congratulations to the Thomas George and Associates for the successful completion of the Virtual Moot Court Competition 2025.
Thank you, madam.
Thank you, ma'am.
Thank you so much.
Congratulations.
Thank you, sir.
Thank you,
all
sir.
the team members and winners and runners.
Yes.
In
yes.
fact, everyone has done extremely well. But only one should be declared. Yeah.
It is an effort of 6 months, sir.
Yeah.
So, without further ado, we'll start the photograph session. We'll take the first photograph. Shubhra Singh, and are you there on camera? Shubhra Singh and Harish, yes. We'll add on spotlight. Yes. And Aditya Bura, are you there on camera? Anuhya Vaisarsu, are you there? You can join, ma'am. Yes. So I'll say 3, 2, 1 and cheese, and we can smile. 3, 2, 1 cheese. 3, 2, 1 cheese. Okay, I now call forward the winners. That is TGA 18. Please raise your hand so that we can click a photo with you all. TGA 18, you need to switch on your camera. Yes, TGA 18 is here. TGA 18, the other speakers. Yes, researcher is here. And speaker one also is here. Okay, so all of you, I'll add our team as well. Shubhra and Harish, are you there? Okay, we'll add you people. Yes. Okay. Say cheese. Okay, the next is the runners up, TGA 7. Could you please raise your hand? TGA 7. Is TGA 7 here? I do not see TGA 7. Okay, TGA 7 is here. Your other team members? Yes, TGA 7 is here. And is the researcher there, TGA 7?
He was there actually.
Okay, I do not see as of now. Yes, so all of you, I'll add one more person, Shubhra Singh and Harish. Yes. Okay, so all of you, I see there's one more hand. TG7 speaker 2. Yes, you can lower your hand. Yes, all of you, 3, 2, 1, cheese. Please smile. Okay. Now, the best speaker from prelims, TGA 7 speaker 2 is. Are you there? Okay, speaker 2 is here. Okay, we'll spotlight. So TGA 7 is getting a lot of awards, it looks like. Okay. One, my team has to add. Yes. Say cheese. Yes. Next is best memorial. Do we have TGA 20 over here? Rahul, can you see and tell me if TGA 20 is there? TGA 20, I see one speaker 2 is here. Yes, is there any other TGA 20 speaker? No. Okay. So 3, 2, 1, cheese. All of you smile. I know you all are tired. Last 1 minute. Last we have TGA 18 researcher. Are you here? Yes, I can see you. I must take a special mention of this particular candidate. She's suffering with pneumonia, but she stayed back for her researcher's test and went all alone for nebulization and had come out as a winner. So special congrats to you. Uh, uh, so on that note, with your hard work, you have also got an award. Say cheese. 3, 2, 1. 3, 2, 1. Okay. Our court masters are here. Yes, court masters. We'll just add the court master.
Yes.
Yes. Court masters. Yes, all the court masters are here. All of you, 3, 2, 1, smile. 3, 2, 1, smile. On that note, ladyship and lordship, we are very grateful for giving us your special so much time today. We thank you from the bottom of our hearts once again, and we conclude this edition of the virtual moot court competition successfully. Thank you so much.
Thank you.
Thank you so much.
Shrestha is looking very excited.
Yeah, Sreshta, how are you?
Sanskrit is looking happy.
I'm fine.
You had fun?
Yes, sir.
Good.
Enjoyed
good.
it. Very
It was
good.
such a boring.
Yeah, budding lawyers, be great. It is a long journey. You should have a lot of patience.
You'll all be winners. I'm confident about it. You're proving it. It's only the beginning. You're
Patience.
proving
So bye, good night.
all the best.
Good night.
Good night, sir. Thank you, sir.
Good night. Good night.